Yes, good morning everyone, and welcome to the School of Business, Economics and Law and the 2024 Kurt Grönfors Lecture with the theme The Ocean Climate Nexus in International Law. My name is Lena Ippert, and since this summer I'm the Pro-Dean of this school, and I'm also part of the amazing Ocean Law Group here at the Department of Law that, together with the fantastic support from the faculty administration, is hosting this event. So Kurt Grönfors Lecture is a recurring and open seminar series with themes linked to Kurt Grönfors' broad research interests. And Professor Grönfors was one of the leading researchers in the field of private law, and his main interest was maritime law. Besides being an expert, academic expert, he also had strong connections with the business community in Gothenburg. Kurt Grönfors' development of collaborative research has been followed by new generations of scholars with the interest in the ocean. Today, the Ocean Law Group includes about 20 scholars, professors, senior lecturers, postdocs, and PhD students with a broad and also deep knowledge in private law and public law, like environment and sustainability issues. At the School of Business, Economics and Law, we have about 50 researchers with direct interest in ocean-related research and education, but also many colleagues with other relevant competencies. At the university, the ocean is a profile area, and we have a collaborative cross-faculty platform, the Center for Sea and Society, including about 350 researchers. So you can find more information on the website gupen.se/ocean, and there you also find information about ocean-related courses and programs. Today we are honored to have Professor Alexander Proelss from the University of Hamburg and a panel of distinguished guests to discuss the role of international law in mitigating climate impacts on marine ecosystems and the responsibility of states. So by that, I would like to hand over to today's moderator, my colleague, Dr. Nils Krabbe, and I trust you to guide us through this program today.
Yes.
So again,
I will do my best and keep the time, hopefully.
Yeah. Warmly welcome and välkomna.
So, in spite of 3 decades of alarm from the scientific community, humanity stands ill-prepared as we now start seeing the first serious consequences of the existential threat represented by climate change. There is a rapidly closing window of opportunity to secure a livable and sustainable future for all. The viability of humanity living within planetary boundaries rests on the actions we take in the next 7 years. This is the conclusion of the Intergovernmental Panel on Climate Change, the IPCC, in its latest report. The report also lays out the economic imperative for taking actions, finding that the global economic benefit of limiting global warming to 2 degrees Celsius exceeds the costs of mitigation by far. Anthropogenic emissions of greenhouse gases emitted into the atmosphere has already for long affected ecosystems, and while we see the symptoms around us, the effects would have gone much further if it had not been for the oceans. The oceans have absorbed roughly 40% of anthropogenic carbon dioxide emissions since the beginning of the industrial era. So the oceans function as a crash bag in relation to climate change. But this is not without side effects. Ocean acidification is expected to increase and will represent a risk for all calcium-based organisms, even in a scenario where emissions are halted. Combined with the effects of ocean warming, a poisonous cocktail for marine ecosystem is being brewed in our seas. From the side of policy and law, these formidable challenges have been addressed by negotiations under the umbrella of the UNFCCC with its increasingly detailed agreements, including the Paris Agreement from 2015. But more recently, we've seen an interesting development in the international system where climate change is addressed not only by state negotiations, but also by means of judicial proceedings and handled in international courts. Importantly, these cases increasingly connect climate change and related obligations of states to other areas of international law. The keynote of this seminar relates to the landmark advisory opinion delivered by the International Tribunal for the Law of the Sea in May this year. We're also expecting a similar case to be handled by the International Court of Justice soon. So I'm very proud to introduce Professor Alexander Proelss, who is here to reflect on this development. And after Alexander Proelss' keynote, we will have 4 shorter reflections on different aspects of the ocean's climate nexus, provided by a panel of distinguished scholars. And this will be followed by opportunities for raising questions, but first I will introduce Professor Alexander Proelss, who is a professor and holds the chair of International Law of the Sea and International Environmental Law, Public International Law and Public Law at the Faculty of Law at the University of Hamburg. And he is also the director of the Institute for the Law of the Sea and for Maritime Law, IISSR. And while international environmental law and the international law of the sea constitutes the focal point of his research, he has also published extensively on issues of general international law, European Union law, and constitutional law. He has been a member of several national and international research consortia and has advised state agencies, international organizations, and private actors both in Germany and beyond on numerous occasions. And before joining the University of Hamburg in 2018, he was professor for public law, in particular public international law and European Union law, and director of the Institute of Environmental Law at Trier University. So please, Professor Proelss, the floor is yours, and we're so glad to have you here.
Good morning, everyone. Dear Niels, Dr. Krappe, thank you for those very kind words. It has become an academic tradition to, when introducing other speakers, to go far beyond realities, and this was just a prime example of that tradition. But I do appreciate, thank you so much, also to Professor Gippert for the kind invitation. I feel honored to give this Kurt Grönfors, I learned it's the sh at the end of the name, lecture, or rather keynote today, even more so as I'm not a private lawyer, but rather a public legal scholar. So I do know that this is a very specific thing to do. Thank you so much. It is a big honor. Now, Dr. Krappe has already referred to this tendency of bringing climate cases before international courts and tribunals, and this is exactly what I'm going to address in the minutes to come, focusing on the climate-ocean nexus, as the organizers of this wonderful symposium have called it, and indeed the recent advisory opinion of the International Tribunal for the Law of the Sea, which I will call ITLOS in the, say, 40 minutes to come, is, to my understanding, a prime example of how this nexus could actually be emphasized and operationalized in legal practice. Now, the next few minutes are going to be very boring for those who do have insight into the regime of the International Law of the Sea, but taking into account that I understand that the audience is characterized by very different legal backgrounds, I thought it may be helpful to make a few very superficial introductory comments in order to have everyone on the same page. Now, what are we talking about? We are talking about public international law, and in particular the international law of the sea, which is one of the core issues that are dealt with by Gothenburg University's Ocean Group. And the core document of the international law of the sea is the United Nations Convention on the Law of the Sea, the UNCLOS, as it is frequently called in international practice and academia. Now, this is an international treaty, actually quite an ordinary, formally, quite an ordinary international treaty concluded between a big number of states, 170 to this day, the most recent ratifications having been submitted by San Marino and Rwanda, which is striking because we are talking about landlocked states here, already emphasizing that this document is not just relevant for coastal states such as Sweden. This treaty is special in many respects, which is why it has been called by the president of the final conference which adopted this treaty a constitution for the ocean. And part of what I'm trying to submit today has to do with the constitutional character of this international treaty, and I will explain in more detail what I mean by using that term and by supposedly referring to what Tommy Coe meant when he used that word some, oh gosh, what is it then, 22 years ago in 1982. Now, the Law of the Sea Convention is also special in as much as its length and comprehensiveness is concerned. It is the most comprehensive international treaty that has ever been negotiated and adopted. So it is really what Law of the Sea scholars would perhaps consider to be their Bible. What is then also very important in terms of the topic that we are dealing with today is that this is the first multilateral agreement which contains specific provisions addressing the protection and preservation of the marine environment. Now, from today's perspective, this is just logic. Of course, every sensible treaty should include provisions addressing the protection of the environment, but at that time that was almost a revolution, taking into account that until the 1960s, and you can find that in legal articles highlighted, polluting the high seas was considered to be part of the freedoms of the high seas, as weird as that may sound from today's perspective. So, an important document, and I will refer to its provisions in the minutes to come. This convention is based on a dual approach, as it has been called by our learned colleague and friend Yoshi Tanaka of Copenhagen University, in that it joins, or rather merges, a zonal approach, which means that the oceans are divided into different spheres of jurisdiction, with states, different categories of states having been allocated different rights and obligations depending on which jurisdictional zone is at stake, and an ethical approach with regard to which the provisions on the protection and preservation of the marine environment are just the prime example, simply because they apply, even though to varying degrees, to all maritime zones. Why am I saying this? Just because the internal waters and the territorial sea have been subjected to the sovereignty of coastal states, this does not make it possible for coastal states to ignore the needs and requirements concerning the protection and preservation of the marine environment. That's my first preliminary remark. Second preliminary remark refers to ITLOS, the International Tribunal for the Law of the Sea. And being based in Hamburg, one of the privileges to work at the University of Hamburg is that the seat of the tribunal is in Hamburg, which means that there is a lot of cooperation between my group and the judges and staff of the tribunal. Now, ITLOS is an independent dispute settlement body which was established by the UN Convention on the Law of the Sea. It is a separate international organization. It's not a United Nations organ, but it's very closely affiliated to the United Nations by way of conclusion of a cooperation agreement and in terms of the immunities of the staff and judges of the tribunal, and so on and so forth. The statute of the tribunal is included into the United Nations Convention on the Law of the Sea in one of its annexes, namely Annex 6. Okay, so this tribunal was established by the convention. It didn't exist before. It consists of 21 elected judges, depending on the case at hand, plus ad hoc judges, and you can see the current composition of the tribunal on that little picture. It's a wonderful building. Whenever you have the chance to visit Hamburg, it is possible to have a tour at the tribunal. It's definitely worth doing so. Now, when it comes to dispute settlement and the resolution of conflicts on the international law of the sea, the UNCLOS, the Convention on the Law of the Sea, also contains very dedicated and specific provisions. When ratifying the convention or at any later stage, the contracting parties have the right to submit a declaration by which they pick and choose one out of a list of 3/4 dispute settlement bodies. Those bodies are the International Court of Justice in The Hague, the ICJ, ITLOS in Hamburg, and a so-called Annex 7 arbitral tribunal, meaning an ad hoc tribunal, which is then created just for the purpose of resolving this one dispute. For very specific categories of disputes, namely with regard to fisheries and the protection of the marine environment, there is the possibility of creating a special kind of arbitral tribunal. It has never happened so far, and I don't think it is of big relevance for the future. So essentially, we are talking about 3 dispute settlement bodies from which states can choose. Sweden has chosen the ICJ, the International Court of Justice. Germany has chosen ITLOS, ranked 1, the ICJ ranked 2, and an arbitral tribunal ranked 3. That's a bit of a weird choice, but let's not comment on that any further. Now, when it comes to the acceptance of international courts and tribunals, then ITLOS has been chosen by 37 states, which is a fair number, as their prime, not exclusive, but their prime organ to settle disputes. Why am I mentioning all this? Because we need to know which court is competent to address and adjudicate on disputes between the contracting parties to the Convention on the Law of the Sea. Now, Sweden having picked the ICJ, Germany, or let's assume another state, has chosen ITLOS. Which tribunal will then be competent to decide the case? It will always be, by way of a default rule, an arbitral tribunal, which is the most sovereignty-friendly version, taking into account that states choose the arbitrators. Right? So this is the background. That being said, ITLOS in Hamburg has been allocated some quasi-exclusive competences. I'm not going to comment further on this, but what I would like you to take into account is that this also arguably includes, and I'm going to deal with that in some minutes, an advisory jurisdiction. An advisory opinion is something else than a judgment. Judgments are binding for the parties. Advisory opinions are, as I will highlight in some minutes, not legally binding per se. But rather what the court in that situation does, it offers its interpretation on the state of the law to essentially not only the states that have requested the advisory opinion, but rather to all contracting parties. Now, de facto, as you can imagine, the legal strength of such advisory opinions is quite similar to those of binding judgments, even though they are not legally binding per se. But once you have a precedent and an expression of a court or tribunal on what the law says, this will essentially more or less be taken as reflecting the state of the law. And that's important for the advisory opinion that I will deal with in some minutes. A few words on context. First, this is something that Dr. Krabbe already mentioned by saying that in recent years, there has been a development that courts and tribunals on all different levels of the law are used in order to achieve more stringent climate mitigation outcomes. Now, first of all, this refers to the domestic legal system. It includes tort cases between private actors. In Germany, for example, there has been a case before the Landgericht Essen initiated by a farmer from Peru challenging the conduct of RWI, which is one of the huge energy providers in Germany, for RWI's share of emissions, of global CO2 emissions, and then arguing that that percentage for which the energy provider is actually responsible in terms of CO2 emissions should also be the amount of the percentage concerning the amount of damage that has happened because of climate change to the property of that farmer in the Andean mountains in Peru. It's still pending. Court of first instance said no way. Court of second instance said, oh yes, there may be a way. Let's rather take a closer look at the evidence. How's that going to work? Now the judges fly to Peru in order to, take a look at the glacier situation in the Andean mountains. Believe it or not, this has happened. You may find it funny, but they have done so. And of course, within the legal community, some people said, well, nice trip to Peru. Maybe that was the real reason for them going to that place. Now, joking aside, all this has been summarized under the headline climate change litigation, using courts as a strategic tool to make it possible that relevant actors take more stringent climate mitigation measures. Now, I refer to tort situations, but this also includes domestic cases brought from NGOs or private individuals against their own state. In the Netherlands, for example, the famous Urgenda case. The same has happened in Germany. We have had 2.5 years ago a very famous constitutional complaint being submitted to the Federal Constitutional Court, which was actually successful, by which the German state authorities, meaning the government, the federal government and the legislator, were required as a matter of constitutional law to strengthen the German climate change framework legislation, initiated by a group of individuals and young people of the younger generation. Third category, individual complaints brought before human rights courts on the international level, for example, the European Court for Human Rights, and you may have read some reporting on the case which was drafted by a group of Swiss nationals against the Swiss government, which was recently decided. Finally, last category, interstate disputes, which have not yet appeared, but which may appear in the future between states of the global south, for example, challenging or rather questioning the conduct of states of the global north and asking for some kind of compensation for climate-induced damage. Not yet, it has not yet happened because of issues also concerning causality. And the question is there something like, a common responsibility of states of the global north under public international law? A very difficult question. And because of those difficulties, some actors have made recourse to advisory proceedings. Because it's, as I will show to you right now, far more easy to get an advisory opinion than to fulfill the requirements concerning an interstate dispute. So does then the International Tribunal for the Law of the Sea has such advisory jurisdiction? You may be surprised that I'm asking this question, but I'm asking this question because the statute doesn't say so. And obviously courts are not empowered to empower themselves, to resume competences which have not been transferred to them by states under the Law of the Sea Convention. That said, the ITLOS in its first advisory opinion as a full court in 2015 accepted, surprise, surprise, that it has advisory jurisdiction, notwithstanding the fact that around 50% of the states that made comments before the tribunal in those proceedings said, listen guys, you don't have advisory jurisdiction, so you shouldn't, come up and submit an advisory opinion. Now, here we go again with the precedential force of advisory opinions, because since that advisory opinion, the case is actually decided. So most will today say, yes, the tribunal has advisory jurisdiction as a full court. And the provision that has been referred to by the tribunal is this article, just give me, it's the wrong one. This one should be the one. Article 21 of its statute, let me go down a bit, which refers to disputes, but then also includes the terminology all matters specifically provided for in any other agreement which confers jurisdiction on the tribunal. All matters, the tribunal said, must mean something else than disputes. That's not uncontroversial in legal scholarship, but as I said, this is the way how the tribunal has decided that situation. So what is then necessary is another agreement creating the advisory jurisdiction of the tribunal with regard to the interpretation of the UNCLOS or that other agreement. And this is what has happened in the case which I'm going to talk about in the next few minutes, namely the COSIS agreement. COSIS is the Commission on Small Island States and International Law, which has been established by originally 2 states. One from the South Pacific area, one from the Caribbean area. Those 2 states negotiating an international agreement, and the sole purpose of this agreement is to request advisory opinions from the International Tribunal for the Law of the Sea. And you can easily understand that not all states in the world are happy with this conduct. But ITLOS has said it's generally fine. The legal effects of advisory opinions, I already mentioned that they are not strictly legally binding, but they are actually used and referred to as authoritative statements on the state of international law. I would argue that they are indeed subsidiary means for the determination of international law in terms of a provision codified in the ICJ statute. And interestingly, a special chamber of ITLOS referred to an advisory opinion of the International Court of Justice in terms of, once saying we should take this into consideration, but they just didn't not only take that advisory opinion into consideration, but rather treated it as an undisputed fact. And that de facto means advisory opinions are treated as if they are legally binding, even though they are not. So a nice way to possibly circumvent the strict requirements concerning dispute settlement, because you just need 2 states establishing an international body requesting an advisory opinion, and then you can get a statement by ITLOS on the interpretation of the Law of the Sea Convention. This may be, something very positive, because the law will develop. At the same time, it is not done in the traditional way how the law develops under international law, namely by the practice of states. And that's why it is a bit of a thing to debate. Second, background, fragmentation. In the title of this seminar, we are talking about a nexus between the law of the sea and climate change law. Well, that is because, as the International Law Commission of the United Nations has highlighted already back in 2006, over the decades, highly specific sub-areas of international law have been developed. And you can see a list of those areas on the slides, many of them possessing their own institutions and principles. So, in other words, public international law has become a fragmented system, and it is very difficult to put together, to create the nexus between those subfields. And if you take a look at the slide, you do see the International Law of the Sea as one of those regimes, but you also see international environment law, including climate change law, on the other. So this is where we are. We need to have some kind of nexus. Is fragmentation something negative? Certainly not only. It is also a sign how much international law has developed over the years, but for sure, and this is again a quotation from the ILC, the International Law Commission of the United Nations, and I quote, "Fragmentation does create the danger of conflicting and incompatible rules, principles, rule systems, and institutional practices, thus potentially undermining the effective implementation of international law." End quote. And we need to keep that in mind, because that is a serious risk. If one portion of international law can be used in order to kind of circumvent the requirements of another portion of international law, this may, in particular in the context of climate change, lead to disastrous outcomes. So how can we then, you see, finally I'm there, create this climate-ocean nexus? And we see that already. Dr. Krabbe highlighted the fact that there has been already 2 requests for advisory opinions before International, it's actually 3. The other one before a human rights body. I'm not going to talk about it here. But if you can't read, it's too small, I know. But if you compare the 2 requests, then there is clearly an overlap. And now, since May, we do have the advisory opinion of ITLOS. What is the ICJ going to do with it? Is it going to follow ITLOS? Is it going to take a different position? This is just an example of institutional fragmentation and the risks that may be involved in that. I don't think that these risks will become manifest. I'm pretty sure the ICJ will accept the advisory opinion of ITLOS, but at the same time, this is just an example of what I'm talking about. The factual situation concerning the ocean climate nexus is crystal clear. Many of the dangers and risks concerning the marine environment have already been highlighted in the introductory remarks. I'm not going to go through all the list. Ocean acidification, influence of abundance of living marine resources, destruction of habitats, sea level rise. There is many more issues that could be listed here. All of this has been compiled and included in the most recent reports of the Intergovernmental Panel on Climate Change, the IPCC, that has been referred to by Dr. Krabbe already. But that's not all. That nexus, and that is increasingly becoming relevant, also has a different perspective. Too much text on the slide, I know, I'm sorry. My typical problem, you don't need to read all this, but what I'm trying to highlight here is that the ocean is also by far the largest carbon sink on Earth. In other words, we need the ocean in order to be able to achieve our climate targets under the Paris Agreement on climate change. And there are ongoing research projects in many parts of the world that analyze how and whether it is possible to increase the CO2 uptake of the ocean in light of the fact that as of today, it is not very likely that the temperature goal of the Paris Agreement is achievable by just cutting down emissions, simply because we are not cutting down emissions to a sufficient degree. So we need, in particular with regard to emissions from certain portions of the industry that cannot be avoided or that are very hard to avoid, we do need some kind of supplementary activity. And those activities are carbon capture and storage, of course, and carbon dioxide removal. Now, COSA's advisory opinion. I'm calling it this way because it has been submitted on the request of the Commission on Small Island States, COSAS. What were then the most important issues emphasized by the tribunal? And let me once again highlight here that this advisory opinion directly referred to this ocean climate nexus. If you take a look at the questions that were presented to the tribunal, you can see that the COSAS referred to specific obligations of states parties to UNCLOS to prevent, reduce, and control, and to protect and preserve the marine environment in relation to the deleterious effects of climate change. So what do states need to do in order to reduce, control, avoid the effects of climate change, such as ocean acidification, on the marine environment? Why is that an interesting question? Because, as you can imagine, 1982, the convention was adopted. It's silent on climate change. It doesn't refer to the term. So the big question that has been debated in legal scholarship is it then applicable? What were the main findings? No detailed explanation. Happy to answer any specific questions from your side in the Q&A question. So this is a summary, and I know that I'm being brief here. First, and perhaps most importantly, as was recently at a conference in Hamburg, where some people present in this room participated in, was highlighted by the lead counsel of COSAS in the proceedings. The tribunal accepted that the emission of greenhouse gases into the atmosphere is pollution of the marine environment under international law. Again, no detailed explanation required here. I copied the legal definition of pollution of the marine environment onto the slide. This is codified in UNCLOS itself. It consists of 3 elements. First, we need to have substances or energy. Greenhouse gases clearly are substances or energy. Secondly, there need to be some kind of introduction into the marine environment, directly or indirectly. Well, emissions, greenhouse gases are emitted into the atmosphere, but from the atmosphere, because of the carbon storage potential of the ocean, they will be absorbed. That's indirect introduction. And third, which are results or is likely to result in negative effects on the marine environment. Well, taking into account the state of climate science, we know that this is exactly the case. So the tribunal concluded greenhouse gas emissions by the contracting parties are pollution of the marine environment. Now that may not sound dramatic, but if you then take into account that that renders every individual provision of the convention applicable to climate change that refers to pollution, you know that this may have dramatic consequences. All provisions concerning the protection and preservation of the marine environment have now become applicable to greenhouse gas emissions, meaning all obligations of contracting parties now also extend to greenhouse gas emissions. So from that perspective, COSIS, the Commission on Small Island States, was absolutely successful in achieving what it really desired to achieve. No excuses anymore to the global north. That's essentially what they intended to say. What you do is pollution of the marine environment, and you need to fulfill your obligations under the Law of the Sea Convention, in brackets, even though the Law of the Sea Convention doesn't mention global warming and greenhouse gas emissions. End of bracket. So this really is a contextual interpretation. Secondly, the very first provision of the Law of the Sea Convention addressing the protection and preservation of the marine environment is super broad. And with super broad obligations, you know that contracting states will always argue, well, it's not really an obligation at all. It's more like a political, please, would you be so kind to do a bit? And then states say, yes, I tried hard, but it wasn't enough. I'm so sorry. Wrong. The tribunal said it had already said so before, but it came up with a couple of very strong statements concerning the legal, mandatory character of the provisions concerned. And it even went a step further by saying this also includes categories of pollutions that we do not even know of today. So, in other words, the entire convention is what then the tribunal called a living instrument, which can be adapted without changing its wording to future challenges. I sometimes wonder, had states parties realized what is actually included in the convention? Had they ratified it? I wonder. Some, of course, yes, and I know that I tend to be a bit cynical here, but at the same time, come on, state interests are not just exclusively focusing on the protection of the environment, as we know. ITLOS, and now we are getting really close to the nexus between ocean and climate change, also highlighted that it considered that not only when the term pollution is used, but also all of the other provisions concerning the protection and preservation of the marine environment should be, weird vocabulary, should. Is that a binding obligation, or is it just, a position of the tribunal? Should be interpreted in line with the United Nations Framework Convention on Climate Change, the UNFCCC, as it has come to be called, and the Paris Agreement on Climate Change. So again, strengthening the nexus. Third, all this sounds great from the perspective of climate change, but what then is the standard to be applied to all of these obligations? And here, the tribunal, in line with its previous jurisprudence, insisted on the fact that the obligations concerned are only obligations of conduct, not of result, which means there is no obligation to completely stop polluting the environment, but rather duty of conduct, you have to do your best in order to contribute to preventing it and to reducing it. And the standard to be applied is a standard that is also broadly discussed in private international law, is due diligence. According to the tribunal, due diligence is a very flexible standard, and it very much is affiliated to the specific case. But the tribunal also said is that because of the massive risks of climate change, the standard need to be stricter than with regard to other situations. The more risky a certain impact on a certain portion of the environment, the stricter the standard of conduct. And the tribunal very strongly said this is clearly also be based on the existing scientific information, which it accepted as a fact. No matter the discussion on legitimacy of IPCC reports, the tribunal said this is what we know today, and no state has the right to reject that anymore. Again, a very strong statement concerning scientific knowledge. This was all brought up in the context of what is necessary under the law of the Sea Convention. And as I just said, climate science was allocated an extremely important role. I think I can skip this slide. I mentioned the great relevance of the IPCC reports, which were referred to with the term authoritative assessment of the scientific knowledge on climate change. The tribunal even referred to the fact that the IPCC reports are subject to permanent review. Consequently, they need to be accepted in terms of a factual basis for international courts and tribunals. An interesting question, and I'm slowly coming to an end, is how to deal with existing and persisting scientific uncertainties. Because every climate scientist will tell you, well, you know, and that's also what the IPCC does, we are using probabilities, but we don't know for sure, right? Climate science is based on the idea of different scenarios, some of them being worst case, some of them being best case, but we don't know for sure which one of those scenarios will become the reality. And we are also uncertain on the reliability of the models that are driving these processes. Of course, not to completely, right? But at least as with regard to the details of the outcome of the models, there still is scientific debate. How to deal with that? And that has been used in all various kinds of environmental cases by states to say, well, since we don't know, we don't need to take stringent measures, right? Because we don't know. Wrong, the tribunal emphasized. This is not in line with a very controversial but an equally important principle of international environmental law entitled the precautionary principle or approach, stating that scientific uncertainty shall not be used to take positive measures for the protection of the environment or in relation to climate change. The question, however, is, and that's subject to controversy and discussion, what exactly is then the legal consequence of applying the precautionary approach? Is there a duty to act, even if there is, you know, just some kind of hypothetical risk, or is there broad scope of discretion of states? This is something which is not yet decided. What then are the tools to establish the climate-ocean nexus that ITLOS has emphasized? How did it do it in terms of legal methodology? Well, first, allow me to highlight again that the law of the Sea Convention has been constructed and labeled a framework convention which must be specified on the global, on the regional, but also on the domestic level. Many of the provisions concerned say states shall, you know, adopt measures in order to take action against, for example, land-based pollution. The convention then doesn't say which measures, but there need to be some specification. And sometimes the law of the Sea Convention also specifies what kind of measures should be taken by referring to other external international rules and standards, and that is something I will mention in a minute. Secondly, the tribunal, in accordance with the dominating view in scholarship, has been considered a living instrument, which means it is open for development. It can be adapted to new challenges, and this is exactly what the tribunal has done. But once again, that's just the precondition for enforcing, or rather implementing, the ocean climate nexus. But what are the tools? Two of them. First, interpretation. Interpreting the law of the Sea Convention in line with climate change law. This has been highlighted by the tribunal at numerous occasions, And it is also possible under the rules of interpretation in public international law, which are codified in Article 31 of the Vienna Convention on the Law of Treaties. These rules of interpretation make it possible and actually require states to interpret, and courts, interpret international treaties in a dynamic and integral manner, namely in line with other agreements which have been concluded by the states parties. And this has been used by ITLOS in order to make it possible to interpret the Law of the Sea Convention in line with the climate change treaties. Interestingly, the Law of the Sea Convention contains a separate provision on the matter of interpretation by referring, and you can see it on the slide, to the fact that the provisions of UNCLOS are, I quote, without prejudice to agreements which may be concluded in furtherance of the general principles set forth in this convention, end quote. And ITLOS has considered the UNFCCC and the Paris Agreement of being such agreements. Whether that is convincing is, in terms of, formal legalese, so to say, interpretation is a matter of debate, but the outcome, I would argue, is quite convincing. Second tool, and yes, I'm nearly done, in order to not steal time from my colleagues for their comments, is not interpretation, but rather implementation. I do think there is a big difference between the two categories. Now, implementation means to kind of specify and put into legal reality the content of the Law of the Sea Convention. And as I tried to highlight before, many of the provisions concerning the protection and preservation of the marine environment actually require that they are implemented on different levels of governance and law. Often, this has been done by referring to activities of what the Convention calls the competent international organization. If we are talking about shipping, the competent international organization is always the IMO, the International Maritime Organization. But there may be other competent international organizations that have a word to say in what is then the standards to be applied by the states parties to the UNCLOS when taking measures concerning the protection of the marine environment. And as I said before, this always also includes measures to combat climate change. There's a lot of debate about what exactly those references to other international agreements include. For example, and you can see that on the slide, it's again too much information on it and not, the font size is perhaps not ideal. The wording of the relevant provisions differs, so it's a matter of interpretation what is meant by those. And we are using, frequently today, using the French term renvoi, which is an international private law term, a reference to an outside, to another rule. Now, what do these outside, those external rules mean, question mark? Would they perhaps also include soft law? Would they perhaps also include everything that has been decided by the Conference of the Parties of the United Nations Framework Convention on Climate Change? If the answer is yes, you can actually use the Law of the Sea Convention in order to integrate the entire climate regime. I don't think that this is possible, but it is discussed. And we are still confronted with how far can we use those rules of reference. An interesting question, but I'm not going to answer it in my talk, but rather make a full stop in a second in order to leave something for debate, is how far does then the competence of ITLOS reach with regard to those external rules to which the UN Convention on the Law of the Sea refers? Now, this entire debate has been initiated, at least co-initiated, by a very important and interesting, highly dynamic article in a Law of the Sea journal, which was written by the late Alan Boyle. In this article, he argues that the dispute settlement system of the Law of the Sea Convention can be used in order to bring cases, in order to have cases adjudicated on the climate regime. Because essentially, according to his view, everything can be included in the Law of the Sea Convention. This would render the United Nations Convention on the Law of the Sea some kind of mega dispute settlement regime in which you can essentially integrate even human rights or whatever we can think about in order to have a binding, compulsory dispute settlement system which does not exist under other international agreements. But can that really go that far? Question mark. I don't think so, but you know, this is one of the fundamental issues to be discussed right now in the context of the ocean climate nexus. And with that, thank you so much for your kind attention. Once again, thank you so much for the kind invitation, and happy to answer any of your questions. Thanks.
Thank you so much for those very, very thoughtful and very interesting remarks. And at least it leaves me with a lot of questions. And I'm sure it raises questions for many people in the audience. And I beg you to please write down those questions or store them on your sort of internal hard drives, because we will have a discussion at the end of this seminar. But for now, I thank you so much, Professor Proelss, and I will now proceed with our next speaker. Now, here with the Ocean Law Research Group with the University of Gothenburg, one of the things we really strive to achieve is to promote the integration of public law, that is the law of the sea, as addressed by Professor Proelss here, and marry that and integrate it with perspectives from private law. And here to reflect on private law repercussions of this ruling and the issues of climate change is Professor Erik Røseg from the University of Oslo. And Erik Røseg is a professor at the Institute of Private Law with the University of Oslo, formerly director of the Scandinavian Institute of Maritime Law, and seconded to the Center for the Study of the Legitimate Role of the Judiciary in the Global Order, both at the University of Oslo. He has been employed by the University of Oslo since 1982, the year of the United Nations Convention on the Law of the Sea, by the way, except a period in the Ministry of Justice, 95 to 96. The chair of several national and international working groups, works with maritime law, law of the sea, and third-party relations in private law. And you're most welcome to this seminar, Professor Røseg. Please.
Thank you so much, and thank you so much, Alexander, for this very, very thorough presentation. And it's I'm supposed to comment on it, but I must say I agreed with I think everything you said. Also the small critical remarks to the tribunal. And let's see if I'm lucky now. I can. There you go. Ha. That makes it possible for me to say something more about the private law repercussions. Perhaps I should, though, mention this very strange thing about the opinion of the ITLOS. It actually assumes jurisdiction, not only over the sea, but over all emissions, over the landside emissions. It says this will eventually affect the sea, and the sea will affect the climate. And that means that we can risk that the ITLOS will actually involve in what the other international courts are competing in regulating, namely what will happen onshore. Should a state have a duty to, for example, reduce industry emissions in Sweden? So I think this is opening the way for quite some initiatives of the international courts. Luckily, the ITLOS is not as specific as some of the other courts. They just say there is a strict obligation, and it's not an obligation of result, but you have to do something, but they don't really list what you should do. If you read, for example, the European Court of Human Rights, in their opinion, it's a lot more legislative work done by the court. So I'm perhaps more critical than you, but oh God, it was a very clear and nice presentation. Thank you. So the starting point is that there is a clear duty of states to reduce emissions. It follows from the Paris Agreement, really. It's not some news. The news is that this is also a duty under the UNCLOS. And as I said, well, perhaps that's not the best instrument to deal with it. What does it mean? Well, it means jurisdiction of ITLOS. And it may mean that you can use the tools of the UNCLOS to enforce these obligations. But these tools, they relate very much to pollution at sea. It's much jurisdictional provisions. So the toolbox that are enabled by this advisory opinion is rather limited. I think the obligation of states goes beyond public law. And I think we really need to consider the obligations of states in furtherance of the public law obligations. And I think states generally would need some private law legislation to fulfill their duties. One example, so you know what I'm talking about. I'm a voyage charter, and the ship owner is very slow, and he says, "I go slow steaming to preserve the environment." And I say, well, the traditional duty is due dispatch. That means a little faster than slow steaming. And it's true that you save a lot of energy and therefore a lot of emissions by going slow. Should voyage charter parties be interpreted so that they allow slow steaming? Should due dispatch be interpreted so that it allows slow steaming? I think perhaps we may have an obligation here for states to open up for a more environmentally friendly interpretation of, for example, charter parties. And then, if states introduce different kinds of measures, they would need to consider not only are there sanctions on parties with great emissions, but also how are these how are these duties distributed? And we have to see what will be the effect, not only on climate change, we know that, but on the sanctions against climate emissions, GHG emissions. And again, that will be something, a duty of the states to look at. And I think this is not only for legislators, this is also a duty of the courts in these states. The commercial courts would have to entertain claims that, well, these kinds of charter parties were interpreted in one way for hundreds of years. But perhaps now it's time to change that construction of the text. Of course, not in all countries can the courts invoke obligations of international treaties. You may have a dualistic system, as you have here in Sweden, we have in Norway. But I think time has come for commercial courts also to have an environmental view in the discussions. For example, on the interpretation of charter parties. And they have to consider what is the most efficient cost distribution of these climate change sanctions. And one example is the ETS emission trading system, where you have to pay to get an allowance to emit GHG. The initial cost distribution under the European system is that it's the ship owner who should pay. Then you have to really analyze, well, what will happen then in the market? Well, certainly that will affect the price, at least for new charter parties. And will that be the most efficient? Would, for example, the sanction hit the person who can decide the speed of the vessel and thus the amount of emissions? And then you have to consider the cost redistribution in charter parties. Will the charter have to pay this? For example, because it's a cost that is dependent on the voyage. The rules vary from state to state. But you have to consider it. And you have to consider that you need the best solution here for the environment. And there is also a cost redistribution sometimes in the environmental legislation. And one example is the Emission Trading System Directive. It has a clause referred to there. It looks like this. And the crucial sentence is that the shipping company is entitled to reimbursement from the charterer in many cases. Maybe that's helpful. I think the ship owners lobby got that into it. But will this be cost effective? And what will happen then if the charter is under English law? And in England or Great Britain is not a party to the EU. And will not feel compelled by this clause. So perhaps then you have to overrule the English court's established jurisdiction in the EU to enforce this obligation here. There's a lot to do in the private law field. I don't say this is uncomplicated, and in my last slide I will just show how complicated this could be. And I imagine that you have a ship going towards a port, and it doesn't have to hurry anymore because they have decided that the slot, the time for discharging the vessel should not be decided by the time it arrives, but by some other kind of system. But then could it be that it would still hurry up, still emit more GHG than necessary? Well, if you look at this clause, this curve here, you will see that if it hurries up, it will use more and more energy per hour. And the ship owner knows that he will get that back because there, you see this line here? This is what he will earn when the ship is in the port, the demurrage under a voyage charge party. And if the demurrage rate is high, that will actually encourage him to speed up to earn more demurrage. And the illustration here is just to show that it's not only easy to make good sanctions against great GHG emissions. We have to look at the final result among the contracting parties. And indeed, the courts have to consider this and feel they are at liberty to do so. And I think this fits well with the obligation of states, including courts, to reduce GHG emissions. Thank you.
Thank you so much, Professor Proelss. Again, this raises many questions, and please keep them in mind. And I will also take the opportunity to say that this issue of promoting climate-friendly shipping by means of private law incentives is one of the focus areas of the research group of ocean law here, with one PhD candidate writing exactly on these issues. So hopefully some good advice and proposals for solutions coming up in the coming years. But thank you very much for that thoughtful presentation. Now, we mentioned two important effects on the oceans of climate change, one being ocean acidification, the other one, of course, being the fact that the oceans get warmer. And as a result of that and the general atmospheric warming, of course, ice melts, and this results in sea level rise. And to discuss this important issue and its legal implications, we have with us an alumni from the University of Gothenburg, and I'm very proud to say this. This is what you might become like if you take the Law of the Sea courses with our department. Snåla Garnadottir, who is an associate professor with Reykjavik University. She teaches public international law, law of the sea, and international environmental law. And Snåla is the director of the Center for Law on Climate Change and Sustainability at Reykjavik University, and a member of the International Law Association Committee on International Law and Sea Level Rise. Please, Snåla, the floor is yours.
Thank you so much. So just next. Yes, perfect. Good morning, everyone. I'm so happy and honored to be here in such esteemed company. And also, as Niels mentioned, I did my exchange semester here at the University of Gothenburg and was fortunate enough to be taught by Gabriella. And I lived on Styrsö for this semester, and this was my first introduction to the law of the sea, and just, I was so inspired both by where I lived and obviously the course, and just basically decided to devote my life to the law of the sea, then and there. So the topic of my brief presentation is going to be the legal implications of sea level rise, and particularly I'll focus on how the groundbreaking ITLOS COSIS advisory opinion clarified really these issues. So the two things that I am going to focus my attention on are the obligations relating to anthropogenic sea level rise. So the obligations that states may have to respond, prevent, reduce, control, and protect the environment from sea level rise. And then, on the other hand, stability of maritime limits and boundaries. I'm sure you will have heard something about that in the Law of the Sea course already. Those of you who are students of that course, that as sea levels rise and the baselines and maritime zones that are measured from baselines, basically from the coast, then that's a question of whether we have to move the maritime zones landward with sea level rise and coastal erosion or not. But so first, and I'll spend more time on the first issue. So to dive straight into that, I first just wanted to highlight with this slide that sea level rise is among the impacts of greenhouse gas emissions presented as pollution by COSIS in its advisory opinion request. So that's underlined there. And what this means is just that COSIS asked ITLOS to clarify the specific obligation of states, on one hand, to prevent, reduce, and control pollution of the marine environment, and on the other, to protect and preserve the marine environment in relation to the deleterious effects of sea level rise. So the second question now I'm going to focus more on. In the advisory opinion, ITLOS answered both of the questions in the affirmative. It confirmed that UNCLOS states parties have a due diligence obligation to prevent, reduce, and control anthropogenic greenhouse gas emissions, including as they relate to sea level rise, but also the obligation to protect and preserve the marine environment from present and future harms, including from sea level rise. So that's broader. The question A then, so this reflects questions A and B. A relates to the regulation of greenhouse gas pollution, while question B refers to a broader obligation to protect and preserve the marine environment from these impacts. And I think that the second question is just more interesting in relation to sea level rise, because it is concerned with how states should tackle those specific impacts. And according to the tribunal, that calls for not only mitigation efforts, but also resilience and adaptation action in accordance with the climate agreements. I think that's really important. So then states should regulate greenhouse gas emissions in order to prevent, reduce, and control the adverse effects, that's A, but also take resilience and adaptation measures to protect the marine environment. And in order to satisfy the requirements of Article 192, I know I'm being quite specific here, basing on everything, how brilliantly Professor Proelss already introduced the main facts of the case. But so under Article 192, states must take measures as far-reaching and efficacious as possible to prevent or reduce the deleterious effects of climate change. And then I think it becomes relevant to look at what harms should be addressed and what the marine environment really means to determine whether the relevant UNCLOS obligations extend to deleterious effects on shore. So really how far up this could reach. Sea level rise as pollution of the marine environment. Professor Proelss already showed us the definition really of marine pollution and how that applies. But just to refresh your memory, it's defined in Article 114 which explains, and ITLOS explained that greenhouse gas pollution is clearly under that, fits under the definition. The definition entails 3 elements. That was there has to be substances or energy. They have to be introduced by man directly or indirectly. And the substances or energy must result or be likely to result in such deleterious effects as harm to living resources and marine life, hazards to human health, hindrance to marine activities, including fishing and other legitimate uses of the sea, impairment of quality for use of seawater, and reduction of amenities. And ITLOS noted in the advisory opinion that the deleterious effects that are referred to here are not exhaustive. So that's implied by the terms such as. And ITLOS also noted that UNCLOS neither qualifies the likelihood of the deleterious effects nor specifies the level of harm. So that's still open up for really to interpretation. But so this does qualify, anthropogenic sea level rise qualifies because the 3 criteria of the definition are satisfied. Number 1, greenhouse gases are substances and heat is energy. Number 2, anthropogenic greenhouse gases are substances directly introduced by man, and the heat is indirectly introduced by man. And number 3, sea level rise is among the deleterious effects resulting from greenhouse gas emissions. And ITLOS noted that that can impact critical infrastructure, cause climate displacement, and pose an existential threat for some small islands and low-lying coasts. So then the next interesting question for me is, are states obligated to prevent or reduce all of these sea level rise impacts? Should they take measures as far-reaching and efficacious as possible to address deleterious effects to critical infrastructure, climate displacement, and the existential threat to some islands and even states? And I think that depends on how we define the marine environment, because the obligation extends to address that. I also thought it was interesting that Professor Proelss said, I hope I'm saying it right, that it's peculiar that ITLOS takes jurisdiction over land-based pollution, insofar as they have an impact on the marine environment. But that is specified in Articles 206 to 212. It lists all the sources of pollution. So land-based pollution, if it impacts the ocean, is included, also atmospheric and vessel source and all of that. But I think it's really interesting that, so we're talking about, in many cases, land-based pollution and how it impacts then the ocean. But then what I'm trying to determine now is how far up to land then the impacts that then result should we also be addressing. So it goes full circle, maybe. So then, to determine this, how far on shore really we should be extending the obligation, I want to look at then what is marine environment. It's not defined by UNCLOS, but like I said, I think it's important to determine which deleterious sea level rise impacts we should be governing. Yeah, so whether really we should be just looking at impacts of climate change and acidification on the body of water and organisms therein, or more to the coast and infrastructure and coastal settlements. So Article 114 gives some indication as to what marine environment means, because it mentions estuaries as examples of the marine environment. ITLOS makes clear in the advisory opinion that marine means belonging to, existing or found in, produced by the sea, belonging to or situated at the seaside or bounded by the sea. The term environment denotes the area surrounding a place or thing, the surroundings or physical context and conditions in which an organism lives, develops, or thing exists. And ITLOS also notes that UNCLOS Articles 145 and 211 refer to the marine environment, including coastlines. So this does not seem to be just limited to the water. So it encompasses certain spaces beyond maritime zones established thereunder. Yeah, this is a quote from, a bit of what I'm saying is our direct quotes from ITLOS, so yeah. Not trying to plagiarize them. This suggests that the obligation to protect and preserve the marine environment may extend to effects on the coast and coastal communities, and then possibly means that states are obligated to possibly reinforce coastlines and take other specific measures to protect coastal settlements. So then, just very briefly, I know I'm running out of time, the stability of maritime claims. This is something that I am personally very interested in. It was the topic of my doctoral thesis and my book that was published by Cambridge University Press. These are really, important questions still really to be firmly answered. There are really efforts to try to change the law on these points. So whether the baselines and outer maritime limits remain stable when coastlines change and shift landward and coastal features submerge, or whether they fluctuate to reflect coastal changes. So whether they're stable or fluctuating. Some states indicated in their submissions to ITLOS for the advisory proceedings that they wanted the tribunal to discuss the potential impacts of sea level rise on maritime claims, but this was not dealt with by ITLOS, so it's not answered by the opinion. And the reason is just that it was not among the questions raised specifically by COSIS. The preamble of the COSIS agreement states, among other things, that the parties to the COSIS agreement affirm that maritime zones as established and notified to the UN Secretary General shall continue to apply without reduction, notwithstanding any physical changes connected to climate change-related sea level rise. So the COSIS agreement makes the assumption clear that they think that states should be allowed to freeze their maritime claims against the effects of rising sea levels. But the request does not refer to this provision or in any way really addresses the issue of stable base points, baselines, claims, or boundaries. It just doesn't mention that, and the omission was surely conscious. So, so the state practice for freezing maritime claims against the impacts of climate change certainly is gaining traction, but probably the issue is just not ripe for judicial settlement yet. And it would, if they had asked the question clearly, then that would have risked the tribunal coming back with an answer different from what they wanted. So yes, a pronouncement now by ITLOS on this issue, on whether maritime limits are stable or ambulatory, would have probably been just premature, might not have yielded the desired stability and legal certainty. And possibly this will be addressed by the ICJ advisory opinion, or another ITLOS advisory opinion in a couple of years' time. So then, to wrap up, really the main question: did the advisory opinion clarify states' duties in relation to sea level rise? And the short answer is yes, because ITLOS does consider sea level rise to be among the deleterious effects of anthropogenic greenhouse gas emissions and among the climate change impacts that states must protect and preserve against. The advisory opinion goes quite far in connecting the dots between states' obligations and sea level rise, but it's not very explicit in the approach, and it wholly refrains from pronouncing on the contentious issue of stable maritime limits. So then I think one of the most maybe notable points or main takeaway that I want to leave you with is that ITLOS reads an obligation to engage in resilience and adaptation actions to protect and preserve the marine environment from climate change impacts, including sea level rise. And it finds that these obligations are compatible with those found in the climate treaties, even though UNCLOS makes no reference whatsoever to adaptation and resilience. So that's it for me. Thank you so much.
So thank you very much for those remarks, Snjogla. Very interesting indeed and very thoughtful. So the law of the sea is a very dynamic field. And in addition to the advisory opinion on climate change, another really interesting and important recent legal development was the adoption last year of the new implementing agreement under the Convention on Biological Diversity in Areas Beyond National Jurisdiction. And in those negotiations, our next speaker was deeply involved on the side of G77 and the Seychelles and the small island developing states. And now we will hear about the connection between the ITLOS advisory opinion and high seas protection. And to present that and discuss that, we have with us Angelique Pouponneau, who is a lawyer in the Seychelles and holds an LLM in environmental law, specializing in the law of the sea and natural resource law. She was formerly the Chief of Staff to the United Nations Assistant Secretary General for Climate Action and Just Transition. She previously served as a policy and strategy advisor on oceans and climate matters to the chair of the Alliance of Small Island States, and prior to that, held the position of Chief Executive Officer of the Seychelles Conservation and Climate Adaptation Trust. In 2021, the New African magazine recognized her as one of the 100 most influential African. Angelique has worked in different countries in the Caribbean, Pacific, and the Indian Ocean on a wide range of projects relating to sustainable fisheries, sustainable management of marine biodiversity within and beyond areas of national jurisdiction, and she serves on the advisory board of the UN Ocean Decade. Thank you so much for coming here, Angelique. The floor is yours.
Very good morning, everyone, and thank you so much for this opportunity to present. And I have to say, thank you, Professor Proelss, for putting this idea of the Convention on the Law of the Seas, sort of the Law of the Sea lawyer's Bible. But it seems that I have two faiths in having worked both in ocean and climate, and therefore have these two conventions always at the forefront of my mind. So this year in particular, and I'd like to start off with, very much a setting of where we are when it comes to climate change. It is the warmest year on record. And of course, we've also heard the scientists pronounce that the sea surface temperatures continue to rise and hottest on record. So my presentation is one that argues that the ITLOS advisory opinion makes the case for high seas protection under what the very long title has been shared with you, this agreement on conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction, which from now on I will refer to as the BBNJ agreement. So I think the point on the ocean and climate nexus has already been very well discussed by previous presenters, so I'm not going to labor the point any further, but only to say that the ocean is fundamental as a climate regulator, both on a seasonal to millennial timescale. And we've already, got a good sense when we talk about the Intergovernmental Panel on climate change. It talks about this really critical role that the ocean plays in regulating the climate system. But there's going to be a lot of text on my next slides, and I maybe just be inspired by the photos more than focusing on the text. And because I won't go too much into the detail, you can have the slides and look at those afterwards. But the IPCC, when they talk about the role of ocean, I'd love to just highlight that it doesn't make a distinction between within or beyond national jurisdiction. It speaks about the ocean as a whole. The one thing, though, that I do want to very much point out, that it talks about what we call these, or what has been commonly referred to nowadays as blue carbon ecosystems. And usually they're referring to mangroves, seagrasses, and salt marshes. And it's often thought about that these ecosystems primarily live in coastal waters, very close to national, well, very much in national jurisdiction. But I think it's really worth highlighting that's not always the case. We do have seagrass meadows in sometimes shallow waters that exist beyond national jurisdiction. And one of them is close to home. I'm from the Seychelles, so it's the Saya de Mala sandbank in the Western Indian Ocean that sits on the extended continental shelf, is a sandbank that sits on the extended continental shelf of the Seychelles and Mauritius, but is said in terms of some of the research that it has the largest seagrass bank in the world. I won't go into this. You've heard the findings in terms of what ITLOS has agreed to, greenhouse gas emissions being considered marine pollution to the marine environment. So that point is already made. But I want to deep dive into one aspect that Professor Proelss really talked about or pointed to, and really take a deep dive into that, and thinking about what is the specific obligation when it comes to this finding, but looking at it specifically from the climate angle. And the tribunal agrees that the Paris Agreement, the UNFCCC and the Paris Agreement, as the primary legal instruments addressing this global problem of climate change. And they are relevant in interpreting and applying the convention with respect to marine pollution from anthropogenic greenhouse gas emissions. But is the Paris Agreement the only answer? I think it's worth noting, and I don't know how familiar you are with the Paris Agreement, but the architecture is quite distinct. The premise is based on nationally determined contributions. What that means is every 5 years actually, parties submit these essentially climate policies that they submit to the UNFCCC to say what they are going to do to contribute to this global temperature goal. But does that mean that because they're national, it excludes any activities beyond national jurisdiction? So, it's a question pour un champion for those of you who speak French. Question for a champion. But I want to argue that it doesn't limit that, and I think the tribunal ITLOS goes on to say very much make that argument. So it agrees that the convention, ITLOS concludes that the convention and the Paris Agreement are separate agreements with separate sets of obligations. Whilst the Paris Agreement complements the convention, and here the Convention on the Law of the Sea, in relation to the obligation to regulate marine pollution, the former, the Paris Agreement, does not supersede the latter, all right? So the tribunal does not consider that the Paris Agreement modifies or limits the obligation under the convention, right? So it doesn't limit the obligation under the convention. And in the tribunal's view, the Paris Agreement is not lex specialis to the convention. And thus, in the present context, it is the general principle, but should not be seen as what is limiting the convention in terms of what are necessary measures for states to do. So I want to argue with the backdrop of the science that we know of the role of ocean and climate, knowing that ITLOS has said, actually, Paris, the UNFCCC and Paris is a starting point, but it's not limiting to your obligations. I'd love to argue that, and the tribunal recognizes it, that there is support that in the working group to IPCC report that for the use of area-based management tools, including marine protected areas, as a realistic response strategy to climate change. It states that marine protected areas and other marine spatial planning tools have great potential to address climate change mitigation and adaptation. And I think that's an essential point to make, because oftentimes we focus very much on the mitigation, and I'll get to that very shortly, and forget about sort of this resilience building component of the ocean. And it goes on to say, if they are designed and implemented in a coordinated way that takes into account ecosystem vulnerability and responses to projected climate conditions. And again here, IPCC does not make a distinction between within and beyond national jurisdiction. too much text on a slide, so let's not get too much into it. But also to say that the tribunal recognizes that so far states have taken action, marine protection beyond national jurisdiction, but they've tended to do so within these regional agreements, such as the use of OSPA to put in these marine protected areas beyond national jurisdiction. But then goes on to acknowledge that nothing precludes states from adopting more rigorous measures to protect and preserve the marine environment than provided therein. However, such measures must be consistent with the Convention and other rules of international law. And it goes on to note the BBNJ agreement was recently adopted, right, within the advisory opinion. It doesn't go further than that. And of course, at this point in time, the BBNJ agreement has simply been adopted. It hasn't entered into force. Of course, I've got the statistics here somewhere. We still 47 state party, 47 ratifications away. All right, we have 13 ratifications so far. So with that, I think one of the key questions that's been on many people's minds is, if we sort of go to Bonn and think of the UNFCCC Convention, can action taken on marine protection in areas beyond national jurisdiction be included in your nationally determined contributions? And I mean, politically, sure. Any country can do whatever it likes, really, in its nationally determined contributions. But scientifically, and in preparing for this talk, I reached out to a very good colleague of mine who's the chief scientist for the UK, and he said, no, can't be done. The models, all the climate models and the carbon models already have 25% of 25% of greenhouse gas emissions already absorbed by the ocean, already reflected in the model. And that if countries started including it in their NDCs, they're going to be double counting. So he said, no, bad idea. And I kind of, in a very legal way thought, seems like a scientist's problem. We'll fix the model. So just to say that this is something that people are very much thinking about, but then worth recognizing that countries like Chile have already included in their NDCs how they're having climate-smart MPAs with the potential to boost climate mitigation and adaptation in addition to traditional conservation benefits. So it is already being done. My very good colleague, Professor Gideon, kind of said it's a slightly different when it comes to blue carbon, because blue carbon would be, projects would be adding capacity. It's not the natural capacity of the ocean. So he makes that slight distinction. So just to say that it's still a question that is being discussed amongst practitioners, as well as scientists, as well as, of course, the policymakers. And as you can imagine, oftentimes climate negotiators and governments kind of say, I'll put whatever I want in my national document, right? Yes, thank you very much. And with that, I'll end it here. Whichever convention we are referring to, the primary goal, nevertheless, is the need for deep, rapid, and sustained reduction in greenhouse gas emissions in line with 1.5 pathways. Thank you.
So thank you so much for that, Angelique. Very thoughtful indeed. And of course, in spite of the efforts to reduce climate change gas emissions, we are far from reaching the targets. And this leaves room for technology, and technology is direly needed to help us out of the dire straits where we find ourselves in light of climate change. And to address policy dilemmas in the development of offshore climate technology, we have with us my colleague, Gabriela Arguella, who is an associate senior lecturer here with the school. She is also a research fellow financed by the Royal Swedish Academy of Letters, History and Antiquities. Gabriella specializes in the law of the sea and ocean governance. Her research interests focus on interdisciplinary global environmental challenges related to the oceans, involving multi-scale actors. She has researched various topics, including waste management, pesticides, ship recycling, ship source pollution, ocean governance, and energy transition. But more than anything else, Gabriella is much of the driving force in the Ocean Research Group. Thank you so much for coming, Gabriella, and presenting. Please, the floor is yours.
Thank you very much, Nils, for your kind introduction. And for me, it's a pleasure to be here attending this, participating in this lecture. And I am honored to be part of the Ocean Law Group that carries the maritime and ocean tradition of Professor Kurt Grönfors. So you may be wondering why I actually chose this medieval painting here that portrays a catastrophic flood as described in the book of Genesis of the Judeo-Christian scriptures. This is because I have been looking into how we communicate climate change and how this communication affects policy and ultimately legislation. And communication of climate change is often accompanied by catastrophic messages. We are facing existential threat of our time, massive biodiversity loss, extreme weather events, ecosystems degradation, disappearing states, relocation of entire nations, and growing inequality, just to mention a few. So from a communication perspective, this is very effective for policy because that issue becomes salient. But for taken action, so to meet climate change, we need hope as well. And if you see in this picture, at the end of this picture, there is a ray of light, and it's actually the Ark of Noah. So there is hope in the way. And what is the hope in terms of policy in the European Union is the Green Deal. And the Green Deal is the hope that we are waiting for. And it's phrased in very positive terms, in terms of inclusion, investments, new technologies, sustainable growth, and an important promise that nobody is going to be left behind. But what is not visible in the policy is that climate action is actually not a win-win scenario. There are many trade-offs that are not shown in these policy documents. There are environmental, social, and economic trade-offs that we need to assess. So in this presentation, I will focus on large-scale deployment of offshore wind power and carbon capture and sequestration under the subsea bed that I will call CCS. The Fit for 55 is a package of legislation that wants to achieve in the European Union a reduction of greenhouse gases emissions at least by 55% by 2030. Climate policy at the European Union is very technology-oriented. That means that we have the Net Zero Industry Act that will facilitate the scaling up of climate technologies and facilitating the regulatory scenarios. But this techno-optimism does not question our status quo. That means that we are going to continue to live the way we are, and the model of growth is not challenging the policy either. So let's look. So the ocean is progressively transforming into the last frontier to pursue ambitious climate objectives. So the decision to turn towards the ocean is a persistent inclusion of this space into the exploitative nature of what humans are doing with the marine space. So in such imaginary, the oceans have always been constructed as a commodity, and in the era of climate change, now the ocean can fix the climate as well. But we do not realize how the implementation of these climate technologies are compatible with marine protection standards as well. How these technologies will affect the targets for preserving the marine environment. So let's look at some of these conflicts. The conflicts for offshore wind power, for instance, could be between the user and the environment, but also user-user conflicts. And in these conflicts, there are always temporal and spatial conflicts. And environmental user conflict from a spatial perspective could be, for instance, that we need to build an offshore wind park that overlaps with a marine protected area. And from a temporal perspective, while you are building the structures, there could be noise that could affect the marine species. A similar example we can make for a user-user conflict. Large offshore scale wind power compete for space with shipping and with fisheries, for example. And on a temporal dimension, while you are building or maintaining the parks, fishermen could be excluded from their areas. So in user-user conflicts, there are win-lose scenarios. Most large-scale offshore wind power are being placed in the exclusive economic zones of states. And there are certain marine uses that have de facto preference when you plan for these developments. And one of them is shipping. Navigation ranks very high when you are planning for offshore wind parks, basically because for a consideration of marine safety. You need enough space to avoid collisions and allisions at sea. But fisheries, those are the losers in these developments. This is the use, even in states like the UK, where there are specific legislation for coexistence, they are being displaced. Then, very briefly, CCS, carbon capture and sequestration, has been characterized as a fundamental mitigation technology, especially in hard-to-abate sectors. These include shipping, cement, steel, agriculture. But CCS is dependent on geological storage. There is not enough geological storage on land, so we are looking into sequestered carbon, a massive in the subsea bed. At the European Union, this has gained a political momentum. There is enormous political support and economic support to scale up the technology, despite that we don't have a comprehensive regulatory framework to deal with operational and post-operational phases. I will just briefly mention some of these regulatory dilemmas that we have concerning CCS. And one debate concerns about the nature. What is actually the carbon streams? Many will argue that they are hazardous wastes that should be subject to the Basel Convention on transboundary movement of wastes. Others that are pro sequestration of carbon, they would say that carbon is nothing more than any other type of cargo. While there is a third view that at least there is a hazardous cargo that must be regulated under the carriage of hazardous and noxious substances by sea. In relation to the subsea bed sequestration, it is defined as dumping, and where the London Protocol and the London Convention is particularly relevant. In 2006, an amendment to the London Protocol allowed the sequestration of CO2 into the subsea bed. But there is an important caveat here, that the exportation of waste is prohibited under this convention. That provision was lifted in 2009, but it is not enforced. But despite it is not enforced, the parties, in accordance to the Vienna Convention on the Law of the Treaties, has decided to provisionally apply the amendment. So they are going to start sequestration in the following years. But then there is the most pressing question concerning the sequestration of carbon is long-term liability. We are talking about scientific estimates that you have to monitor the sequestration between 50 to 150 years into the future. So who is going to be liable if there is a massive escape of carbon into the marine environment? Some argue that the host state at some point will have to take this responsibility. And with that, I will just finish saying that climate change, of course, we have to meet this existential threat, but techno-optimism maybe is not our best way forward. we need to start asking the hard questions. Can we live under this model of eternal growth? And up to what extent can we protect the marine environment and deploy these technologies offshore? Thank you.
Thank you so much, Gabriella, and thanks also for leaving us with very poignant questions and also, I think, hopeful and pragmatic questions. So this leaves us with a bit of time for questions and discussions. And I will please invite the panelists up here to the tables, standing if you're not too exhausted. And now feel free, dear colleagues, students, friends, etc., to raise questions. I think we should have 1 or 2 microphones somewhere in the room, or perhaps we could just speak loudly. I think there is a microphone here somewhere. Yes, there is a microphone. So please, questions, reflections. Now is the time. So we have one here. Ellen, please.
Thank you. Thank you so much. Someone has to start, I guess, so I'll give it a try. I want to thank you for organizing this seminar and for all the extremely interesting introductions. I'm a private lawyer myself, so many of these things were kind of new to me. I learned a lot. I have a question to Angelique, is that right? Because I'm Norwegian, and a few years ago we had a lawsuit in Norway. A few NGOs challenged the Norwegian government when they tried, or they accepted opening of new old oil fields in the Barents Sea, and whether this was in line with the international obligations under the Paris Agreement, for example. And as you said, the Paris Agreement says that the responsibility for the states is the emissions within their jurisdiction as a starting point. At least this was what the Supreme Court landed on. And they said that although opening new oil fields and taking out more oil would lead to more emissions and would be clearly against the Paris Agreement, they said that most of this oil is exported out from Norway and will be burned somewhere else, and hence it's not within the jurisdiction of the Norwegian Supreme Court to decide on this, and hence there was nothing hindering the Norwegian state for giving permit to open, or to at least investigate whether new oil fields could be opened in the Barents Sea. And I was with interest listening to your interpretation of this situation, and I wonder if you could elaborate a little bit more on that. Thank you.
Please, Angelique, yes, if you'd like.
Oh, I have a mic on. Yeah. Thank you so much for a very interesting question and very insightful. I haven't read the case, I'm afraid. So thank you for giving me the context. And I think this is, in my humble opinion, quite an unfortunate way of looking at things, especially, and it has increasingly become an excuse in the way in which we account for greenhouse gas emissions and who's polluting and versus who's consuming versus who's producing, and it's leading to a lot of inequity around the world. I don't have a sort of a legal take or a legal response, but very much a political response, and that, very oftentimes many countries, developing countries in particular, are seeking energy security and in doing so seeking it from sources from elsewhere, and have increasingly been vilified for doing so. And so it's really interesting to then hear that those countries who are providing this initial source are then saying, not really my problem because it's going to be burnt elsewhere. So it's tragic that we've now used this national as an excuse for our obligations. And I think, to my point, that we need to think about it more broadly, and think about how we're how it's influencing things beyond our national jurisdictions. But thank you so much, and sorry for a more political response than a legal one.
No, I think it was a very valid, very interpretive. So I think Professor Proelss would perhaps also like to address. Yeah, absolutely, yes.
It really was an interesting case. What I would like to say is there's a common misunderstanding in how the Paris Agreement is, what it actually includes. The Paris Agreement doesn't say at all that Norway has to reduce its emissions to this and that % measured against the year so and so. The thing what it says is Norway has to report its climate objectives. And there is a global temperature goal which is not by the Paris Agreement distributed among the states. Now, this has been done on the EU level and within many of the domestic legal systems, and I have no idea whether that has been done by Norwegian legislation. In Germany, it has been done, but the Paris Agreement doesn't say this. And second, Angelique is absolutely right in saying that accountability is one of the big problems. Now, some of the issues which you raised have been solved by the Paris Rulebook, which is a collection of internal, regulations whose legal status is far from clear, whether it's that legally binding, does it have some kind of external relevance for a court, for example, which tries to, to make sure that states don't try to circumvent any of their climate objectives. But there is still gaps, and those gaps urgently need to be addressed so that there is clarity and certainty in which state is responsible for which kind of emission in cases of export, in cases of transport, and in many other, and on the high seas, as you correctly pointed out. So there's still uncertainties involved, and then there is the uncertainty of how can we actually use the Paris Rulebook in court, before courts. So far, the dominating view seems to be no. But I'm not sure whether I would agree to that viewpoint, and I do think that ITLOS has offered some paths to kind of change the understanding of those internal rules within the law of the sea context.
Thank you very much. Interesting thoughts and very good question. More questions? Yes, please. So I think we have a question over here. We have listeners online as well.
All right,
so.
I understand. My name is Bo Malstam. I'm coming from the biological side, but interested in how to apply, of course, with the help of law. And the issue is really on the capture of CO2, as you mentioned, by the ocean up to 40%. And that's a very complicated system. And we have the wetlands and everything, and of course the phytoplanktons and everything now. But one very often forgotten fact are the whales. A single large whale is similar to 10,000 trees in the forest when it comes to CO2 capture. So my question is with this new advisory opinion, could that be helped or used in one way or another to go after whalers? Because I know Iceland's government has, for example, has been gripping around how to stop them. And 2 years ago, they used some veterinary reports that it was inhumane to chase whales. But that was just a memorandum for 1 year then to stop. But now they're back again, not to speak about the Japanese. So this would be a really interesting instrument if we can go after them using this new advisory opinion, because the good, big work that all the whales are doing. And so I think it's interesting.
Yeah, no, thanks for a very interesting question, and I think this is really an increasing sort of research field, the so-called biological carbon pump of the ocean and its carbon binding effect. So very interesting, also connecting to whales. I mean, do we happen to have anyone interested in international whaling regulation and the specific policies of Iceland in the panel? And I'm looking at you. So.
We do. So, yes, very interesting question. I'm actually a member of a working group that is revising the whaling legislation in Iceland right now. So I'm basically just in the following weeks going to be looking specifically, that's like one of the last international treaties that I have left to cover for the relevance of whaling is the UNFCCC and the Paris Agreement. So I think I'm going to definitely be working that into the report, that they might be natural carbon sinks that then the climate treaties obligate states to enhance. So, to basically keep them in the water so that they basically sequester carbon rather than getting them out. But the thing is, though, I wasn't sure how clear the science is on it.
It's very clear.
Really?
I can send you some.
That would be brilliant. Yeah.
It's forgotten. It's as usual in science, the publications get forgotten after 10 years.
Yeah.
But there's some really good publications 10, 15 years old that I'd be happy to send you, actually.
Okay. I was trying to organize an event recently at Reykjavik University about this, and then I got angry people from the profiling side contacting me and sending me actually something about this isn't true that they're carbon sinks. There was some I'd be very happy to get evidence. Yeah, very good.
Because as I understood also in Iceland, it's not only a legislation issue, it's a political issue.
Very much so. Mm-hmm.
We have strong groups against and one whaler in.
Yeah, it's the one whaler who really has a lot of pull. Yeah.
So obviously this panel has tentacles in all sorts of policy developments in this field. So thank you very much, Nolag. Please, I think, Erik, did you have anything to say? No, please then, Professor Proelss.
We have enough time?
Yes, I think
this is so interesting. I'm hearing this for the first time, I have to say. So thank you very much. And the answer is, is there a potential of the advisory opinion on that matter? Yes. Let me briefly explain to you in what way. This duty to protect and preserve the marine environment, which I mentioned, has a dual objective. One is trying to get rid of pollution. The other one is the preservation of the marine environment. And in that instance, the ITLOS referred to blue carbon activities as one of the measures that should be used by states in order to mitigate climate change. And if that is true, I don't have a problem in accepting that that should also include other marine species. And that, again, could potentially impact on the interpretation, we discussed this yesterday, Snorre, right, on the interpretation of the provisions in the Law of the Sea Convention concerning conservation of cetaceans and whales. So the answer is, this is very interesting and it could have a potential impact on the interpretation. Yes.
Perfect.
Thank you very much.
Let's create a group defense.
Yes.
This is great. I can already see sort of cooperation being built on this event. Thank you very much. I have my Law of the Sea students with me here. And I'm so glad you could all attend. And of course, since all of this will come up on the exam, do you guys have any questions? Any reflection, questions? Everything crystal clear? Anyone else with questions? If that is not the case, I will open up for our panelists if you have anything to say in relation to each other's presentations.
I have a question for Professor Proelss. Because I think it's really interesting to think about how the advisory opinion is used in political arenas, and how they can best be used by small island developing states, for example, to advance this plight of addressing climate change, and whether you already see potential political use of the advisory opinion.
Yes, I think that there is a clear potential, but mostly for the group of small island states. And I mean, it has never been a secret that this request for an advisory opinion was the first request for an advisory opinion. And I'm pretty sure that this will be used as the first step in order to come up with further requests. Now that ITLOS has kind of established the legal basis, and let me emphasize, I think the tribunal was very wise in not taking a too dynamic approach. It could have gone further, and some have requested it to go further. I think it was wise to not do so in order to make sure that its advisory opinion will be accepted by its main clients, and those are the states. Not turning their back to the tribunal, oh, these are the environmentalists, let's not listen to what they have to say. So I think from that perspective, the tribunal did an excellent job, right? But it's just the basis, and I'm pretty sure that there will be further requests. There is one issue, however. You see, I tried to highlight at the beginning that when it comes to disputes between states, there are high procedural barriers, right? And those barriers don't exist when it comes to advisory opinions. But you know, once the specific situation of, say, Sweden, Norway, Germany, and so on and so forth is affected, you may bring forward the argument that the advisory proceedings cannot be used in order to circumvent those strict requirements, where in reality there is a dispute between a small island state and, say, Germany in my case. So that is to be, you know, that's something to wait for. What I also can tell you is that I know that for sure that with many states of the global north, even those who publicly applauded the advisory opinion, there is, you know, kind of anxiety behind closed doors and, oh, what could this mean for us and what will it mean for us in the future? So yes, the political discussion has begun, but it's not yet fully transparent, let me put it this way.
Thank you very much. And on that note, we will finalize today's talk. And before I thank you for coming here, I will just briefly mention that in our Ocean Law Research Group, we have dedicated research projects connecting to many of these issues, including CCS technology, blue carbon, slow steaming in shipping, and other different elements connected to the Ocean Climate Nexus. So many interesting things going on here, in addition to, of course, our teaching, which involves 4 dedicated master's level courses on law of the sea and maritime law. So with that, I will thank you so much for coming. Thank you all so much. And here to give you a small gift on behalf of the school is Lena Gippert from the leadership. Thank you so much. And thank you all for coming.